Don't get this one wrong, or you could face months of delays, unnecessary stress, and maybe even a date with an attorney. Hi, I'm Brian Bean with Dream Big Property Management here in Riverside, California. Today we're talking about how to properly, legally, and ethically end a tenancy on your California rental home. We're going to cover reasons that you can ask tenants to move, what rules to follow if you are legally allowed to end a lease, the legal requirements to go about that process, a real-world example that we dealt with recently. We're going to go over some best practices to make that process run smoothly and some common mistakes that could cost you money. But before we begin, let me remind everyone that we are not attorneys, and this should not be construed as offering legal advice. This information is to provoke conversation and awareness. Always consult with an attorney before taking any actions on your rental property. Now, let's get started. Officially, it's called termination of tenancy, but that's very sterile and impersonal. In reality, it's asking someone to leave their home, which is very personal. It's also very important that you follow all the local, state, and federal rules when you do so to make sure you're protected, of course, but also to make sure that it's being done in a way that's fair to your residents. So, how much notice do you need to give a resident to move out of a rental home in California? I wish I could give you an easy answer, but the truth is there's a lot of qualifying questions that you must answer in order to make sure that you're following the proper framework. To tackle the issue, let's start with a simple tenancy. It's a home owned by a small mom and pop owner, sometimes referred to as an accidental landlord. In this scenario, we're talking about a month-to-month rental agreement or a lease that's expired and automatically converted to a month-to-month agreement. In this case, if the resident has lived in the home for less than 12 months, you must give at least a 30-day written notice to vacate. If they've been there 12 months or longer, the notice must be a minimum of 60 days. And if the residents receive housing assistance, such as like Section 8, you must give at least 90 days notice in California. For leases that are in force, these notice periods will still apply, but the required vacate date cannot be before the lease ends. Now, where it gets more complicated depends on the age of the home and who owns the property. Before you make any moves to end a tenancy, you must first determine if the property or the tenancy is covered by California's Tenant Protection Act. In 2019, the state legislature passed Assembly Bill 1482. The Tenant Protection Act covers, among other things, no-fault reasons for which you can ask a renter to leave. To clarify, we're not talking about unpaid rent or lease violations here. This refers to when you want or need to end a tenancy at no fault of the residents. So AB 1482 applies to properties built more than 15 years ago and typically owned by corporations or real estate investment trusts. Small investors often are exempt from the Tenant Protection Act, but there are rules to claim that exemption, and we'll talk about that more in this later in this video. But for homes covered by the Tenant Protection Act, you must have one of the legally allowable just causes to give notice. Those reasons could include: 1, the property is being removed from the rental market. 2, substantial renovations with permits must be completed and no one could live in the property while the work is being done. Or 3, the homeowner or a member of their immediate family is going to move in. In any of those cases, the owner must also provide relocation assistance equal to 1 month's rent or waive the final month's rent. Once you've figured out if you can terminate a tenancy, the next step is to deliver the notice to your residents. We recently dealt with this exact situation. We have a client who owns a beautiful 4-bedroom home in Colton, California, right here in the Inland Empire. After years of living out of state, our client got a job opportunity that required them to move back to California, and they needed their rental property as their family home again. Here's what made this more challenging. The residents had been absolutely fantastic for almost 2 years. Always paid rent on time, took excellent care of the property, communicated professionally about any issues. Our client felt terrible about asking them to leave. That property was titled in the owner's name, not a corporation, and they determined that they were not covered by the Tenant Protection Act. Since the residents had been there for nearly 2 years, we needed to give them a 60-day notice. We used our compliant California notice forms, but instead of just sending the notice certified mail or posting it on their door, we personally delivered the news and the notice to the residents. This allowed us to have a face-to-face conversation with them, and we were able to explain the situation, answer their questions, and maintain that positive relationship that we had built up over nearly 2 years. While the residents were naturally disappointed about having to move, they understood, and I think they felt heard and valued because of how the process was handled. Reality is, you can check all the boxes legally, but if you don't show some empathy and some respect, your residents' pain can become your pain. Now, here are some common mistakes that we see from rental investors. 1, verbal notice. California requires written notice. That phone call or text message, that doesn't count, no matter how clear you think you were. 2, missed steps. A lot of investors could be considered exempt from the California Tenant Protection Act. However, to be exempt, you must notify your residents that you are exempt, or you will not be considered exempt. And 3, lack of knowledge about California laws. Too many investors fail to keep up with the local, state, and federal legislation. And let me tell you, ignorance of the law is not a valid defense. You make a mistake, you write a big check. Okay, so here's your action plan before you serve any notices. Step 1, check with your attorney if you're thinking about ending any current tenancy on your rental property. This could include coverage under the Tenant Protection Act, or could be local ordinances. Step 2, verify your lease type. If it's month to month, the 30, 60, or 90-day rules may apply. If the resident still has a fixed term lease, nothing likely can happen before that lease ends. Step 3, calculate the tenancy length. If they've lived in the home less than 12 months, it might require at least a 30-day notice. Longer than a year probably requires a 60-day notice. Step 4, does your resident receive Section 8 or some other public housing assistance? You may be required to give 90 days notice. Step 5, if you are able to move forward, make sure you're using California compliant forms with all required legal language. And step 6, serve your notice properly. Whether that's certified mail, personal delivery, or posting on the property, make sure you follow the legal service requirements and keep detailed records. Look, when you own rental properties, you're running a business, but it's not just real estate, is it? We're talking about people and the places they call home. Take a few easy extra steps, show some empathy and respect for your residents. Your residents will feel better, you will feel better, and your business will run more smoothly. If you have questions about anything you've heard here today, call me directly at 951-314-5402. You can also find valuable information on our website, dreambigpm.com. And if you're wondering if your home falls under the Tenant Protection Act, we have a quick guide to help you answer that question. Email me, brian@dreambigpm.com. Put Tenant Protection Act in the subject field. We'll shoot you out a free copy. And as always, if you found the information you heard here today useful, please do us a favor, like and subscribe below so that we can help others just like you. Don't be accidental about your future. Be intentional. To your success.